All right, good afternoon. I hope you were able to get some lunch and that it was good. There will probably be some more people coming in, but I just wanted to go ahead and start with this panel to allow for as much discussion as possible. My name is Marietje Schaake. I'm a member of the European Parliament from the Netherlands. I represent a progressive liberal party. I focus on international relations, international trade, and Europe's digital agenda. And for anyone who's been looking into digital freedom, fundamental rights online, it is hard to avoid the discussion around intellectual property rights, copyright in relation to the information society. We've seen hotly debated political fights, both in the European Union and in the United States, as well as in other parts of the world, relating to, for example, the Stop Online Piracy Act, the Protect Intellectual Property Rights Act, as well as the Anti-Counterfeiting Trade Agreement. And neither of these proposed bills have turned into law as a result of a changing debate and a globally emerging resistance to these kinds of laws. But the discussion is far from over, and I'm very glad that we have a very distinguished panel today to discuss. In order to keep this session very dynamic and interactive, we're going to have very short introductions, and we'll try to make this as active and lively as possible. So I really count on you as well to participate. So please, raise your hand if you have a question. Walk towards the lady who's going to be there with a mic. We also have live streaming going on at the same time, and the opportunity for people who are participating online to ask questions, and they will be fed into the discussion as well. So I'll just briefly introduce all the speakers in the order in which they will make their brief remarks, and then we can kick off. We're going to start with Barbara Bukowska. She's a Senior Director of Law and Policy at Article 19. Then we'll hear from Joe McNamee, who's the EU Advocacy Coordinator for the European Digital Rights Initiative, EDRI. Then as a third speaker, we'll hear from Pierre-François Daucuir. He's Vice President of the Supreme Audiovisual Council in Brussels. And then we'll turn to Dmitry Golovanov, who's a lawyer with GSC Web TV from Russia. And last but not least, we'll hear from Robin Gross, who is Executive Director at IP Justice. So a lot of fascinating speakers. We'll look forward to hearing from you, Barbara. Why don't you go ahead and start?
Thank you, Marietje, and thank you also to OSCE for having us here and organizing this really wonderful conference. What I would like to do in my opening remarks is just to give some overall observation about the context of this discussion, where we come from, where we are, and at the same time say some concerns of Article 19, which is an international freedom of expression organization named after Article 19 of the Universal Declaration on this topic. And I will especially try to do what Marietje just said, to come with some concrete proposals or demands, what we want this area in OSCE region to look like. And actually yesterday I asked on Facebook my friends to send me some pictures to demonstrate this topic and tell me what they want. So I want to just show you the picture and demonstrate the topic on those pictures. So the first picture was actually sent to me by my grandmother, and I don't know whether you guys know what it is. This is story for the Bible when Jesus multiplied bread. And obviously it's a joke, but I think that I hope everybody gets it. But I think that what it shows is, and what we really want, is that we really have to go back to the origins of the copyright. That we have to see that the sharing and phenomenon we are describing here is nothing new. And activities such as copying books, making extract, even making the physical cutting and pasting in physical sense existed for centuries. It was cultivated during Renaissance in the classical times, and it was always appreciated as something which preserves the cultural heritage and our access to cultural goods. And it's only very recently when few lobbies started to shrink this space and started to make very concentrated attempts to limit the distribution of the cultural goods. And these attempts were accelerated, unfortunately, by internet and previously ordinary behavior such as borrowing books or CDs for non-profit now can be prevented. And in some countries, circumventing digital locks through digital rights management system is criminalized. And also it's quite dangerous that legally obtained materials can be now exposed to criminal sanction if they exist in digital form. And with the repeated expansion of the copyright terms, and public domain is shrinking so much that most of the 20th century works might not be freely available in times to come. So in this sense, what we want is really to go back to the origin and look at the fact that the purpose of the copyright was to support creativity, to support the cultural exchange, and not stifle the free flow of information. The second slide, this was sent to me by my brother, who is a writer, shows a very misleading argument that is used by the entertainment industry when we are discussing this topic. They are pretending that the argument is very straightforward. The copyright is same as a physical property, should be protected, and in these debates, freedom of expression is totally sidelined. This is very conspicuous in its absence, and when it's mentioned, it's only mentioned as some of the exceptions to copyright terms. But this is unfortunately not true. And when we really go to the international human rights law, international human rights standards, we would notice that the margins of appreciations which are given to the states to limit freedom of expression as compared to the property, including the copyright, is much more narrow. And then proper balance needs to be struck in this discussion. So we really have to go back to international human rights law, look at the way how freedom of expression can be legitimately restricted, and set up very clear criteria for this balancing test. And my organization, Article 19, has recently done this work, and we are releasing a set of principles on freedom of expression and copyright in the digital age, and I encourage all of you to contact me, and I will be happy to share with you the principles. And hopefully there will be a chance to discuss these principles more in detail in the following discussions. Then another picture is actually this. I don't know whether you can see it properly. This picture, I think that a friend of mine sent to me, actually gives quite a response to another argument which is used in discussions, which is what about those poor creators, those authors, those musicians, those artists who are laboring very severely, and you with your freedom of expression arguments and with your expansion and freedom of expression absolutism, you want to deprive of their right to profit from their labor. I don't know whether you guys know what this is. This is a picture of Martin Luther King, who was a great civil rights activist in the United States, and this is a picture when he gave a speech, I Have a Dream, and provided a vision of America based on equality. And it was actually very interesting. I was quite surprised yesterday to find out that this is a copyrighted material. You can use the speech without legally, unless you are going to pay the $20 to Sony corporations, who owns the copyright, and you have to legally purchase the DVD of this recording. And surprisingly, the speech is not available even on the website of Martin Luther King Center. And that actually exposes quite the argument, the sinister way how this argument is presented. That actually, unfortunately, is not always the rights of creators and authors, but interests of the corporations, and in many times also the heirs of deceased authors. And when the argument of copyright, which is to use creativity, support creativity, encourage the creativity, is very dubious in this case, because I don't really understand how ownership of copyright by Sony corporations to this speech is going to support creativity of anyone. So what we want here in this sense, we want to go to the systems and create the systems where freedom of expression is respected, and when there are also systems in place which award creators and they don't and authors and don't tip the balance to the rights of corporations that are exploiting these rights. The last picture is actually, this is the picture of ACTA protest as of 19 February 2011, last year, and maybe many of who are present in this room been involved in those processes. And why I chose this picture is also to show that actually the limitations on the freedom of expression and expansion and support to copyright doesn't often come from the processes which are subject to democratic control. They come from a trade agreements, and this we witnessed this last year with ACTA, but there are other examples. We have the Transatlantic Pacific Agreement, which is being discussed now in total secrecy. The United States is a part of it, and Canada was invited to join the negotiations. And these discussions are done in total secrecy without public being able to contribute and influence these discussions in the same way as entertainment industry is. And what we hear is to restore the democratic participation. We want public to be able to participate and influence the creation of future copyright policies and make sure that the policymakers and legislators and courts are aware of this and make the decisions based on informed decisions and informed information which they receive from the public. Thank you.
Thank you very much. I think we should come back to the balance between the public interest, commercial interests, vested interests, new developments later, but all I can say is from my perspective in the European Parliament, a lot of these voices did reach us, and the end result shows that it was stronger than at least some vested interests, although we have to acknowledge that industry is also diversifying. There are new kinds of industries who have a different approach to copyright than the old ones. But Joe McNamee has been close to this discussion, so please share some introductory thoughts.
Thank you. I always knew it was going to be difficult to speak after Barbara because she was going to say everything magnificently. So just to provide some diversity, I'm going to say everything less magnificently. I'll start off with two simple facts. One is that the OSCE Universal Declaration on Cultural Diversity makes the issue very clear. No one may invoke cultural diversity to infringe upon human rights guaranteed by international law, nor limit their scope. Secondly, so that much is clear. Secondly, there was an update of a publication published recently called The Sky is Rising, giving some interesting statistics about the death of culture online. In France, in the last year, digital music revenues went up by 27%. Between 1995 and 2011, the number of books published in France went up by 79%. Live revenues for music are going through the roof. Of course, some clever person once said that if you torture statistics for long enough, they'll admit to anything. So I don't want to rely too much on pure statistics. So if we come back to the internet, we need to think about what it is. What is this internet that we love so much? The internet uses computers, and computers, whether we like it or not, make copies. That's how they work. And networks create copies because that's how they work. And the internet is the internet because it allows anybody to connect to anybody. That's what the internet is. So if you want computers, if you want networks, if you want the internet, you're going to have copies and you're going to have everyone connecting with everybody. And whether you like it or not, unless you want to re-engineer the internet, that's what you've got. However, all of the lobbying that's happened from the content industry for as long as anyone can remember seems to ignore these facts. And we've had 15 years of injunctions, of 3 strikes, of prosecutions of individuals, of blocking. And at the end of all this, fairly recently, the European Commission produced a communication on intellectual property enforcement. And it said that infringements are ubiquitous. After all of that, infringements are happening everywhere and all the time. So this proves 2 things. That infringement is easy because that's how computers and the internet work. And secondly, that addressing infringements at the edge of the network doesn't work. And for that reason, the most recent strategies are heading away from the edges of the network and into deeper and deeper into the network. And that's what SOPA and PIPA and ACTA and everything else ending in A was trying to achieve. It was trying to get the companies inside the network to change the nature of the network in order to enforce copyright outside the normal rule of law. This was most clear in SOPA. SOPA, I think it's section 105. It's a very long, very boring document. I wouldn't advise anyone to read it. SOPA suggests giving a complete freedom from prosecution for any internet hosting provider, internet access provider, payment provider, any intermediary that you would rely on to have a functioning web presence would have a free card, a right to destroy your online presence if they had a reasonable belief that you were infringing US law. And that's why people got upset, because it wasn't the silly strategies. I mean, it's a silly strategy, but it's a silly, dangerous strategy. So we're moving from silly, silly strategies to silly, dangerous strategies, and that got people out onto the street. And all of this is happening, would happen outside the rule of law, because it wouldn't be based on you breaking the law. It would be based on a reasonable belief by a US company whether that you might be breaking the law. And why do people break the law? And it's partly because people don't think that the law is legitimate. The technological development is a very interesting thing. It makes things better, it makes things easier, it makes things open and free and happy to use. And what we have is, in the old days, before this technology, we could give a book that we bought to our friend. Here, read this book, it's really good. Thanks to technology, with e-books, we can't do that anymore. In the old days, before technology, we could make private copies of music that we'd bought because we might want to have it in the car as well as in the kitchen. Well, thanks to technology and digital rights management, we can't do that anymore. And even more ridiculously, 3 different studies showed that the people who infringe the most, people who file share the most, are the people who spend the most money on cultural goods. So all of these restrictive technologies, all of these restrictive enforcement measures attack the very people that are contributing most to the cultural industries. So to summarize, concrete solutions is what Marietje asked for. It would be nice if legal services were as user-friendly as other types of service. It would be nice if strategy was based on evidence and not on assumptions. And above all, we should stop thinking that we can use internet companies to regulate the internet outside the rule of law, because every relevant piece of international law says that restrictions on fundamental rights should be based on law. Thanks.
Thank you very much. You've said a bit about what would have happened in the cases of SOPA, PIPA and ACTA, but I want to ask you 2 concrete questions, and if possible, if you could answer with yes or no to just kind of do an additional summary of what you said. On the one hand, do you think that the content industry, or those providing content that we all appreciate, is diversifying?
Yes, slowly, if I can use 2
Okay.
words.
Yes, and then can copyright be enforced without infringing people's fundamental rights in the digital era?
Not as it stands.
All right, thank you. I think those will be questions we may come back to with more than 2 words. But we have a few more introductions to go. So please, Pierre, could I give you the floor? Yeah, and you need to use the computer for some slides.
Okay, good afternoon. I was asked to say a few words about the French law known as Hadopi, known as the 3-strike law. So that's what I'm going to try to do in just a very brief overview of many of the deep and important questions that are raised by this law. Very briefly, what the 3-strike law was about was this. So this is a general overview of the mechanism set by the law. It created a duty for every internet user to secure their home internet connection so as to make sure that this connection was not used for illegal purposes, for purposes of illegal downloading. If it was found that one's internet connection was used for illegal purposes, then that was the main symbol of the law. The access could be suspended by a judge. So the system then organizes some sort of surveillance of the peer-to-peer networks. It only concerns peer-to-peer networks. And when IP addresses that are used for circulating copyrighted content are identified, they are referred to the administrative authority called the Hadopi, Haute Autorité pour la Protection des Droits sur l'Internet. And this administrative authority then reacts in 3 different ways, in 3 different times. The strike 1 would be the sending of 1 email, that is a warning that your internet connection has been used for circulating copyrighted content. Strike 2 will happen in case of a second infringement within 6 months, and it's an email plus a registered letter. So it's a more formal warning that you are using your home internet connection for circulating, downloading copyrighted content. And then strike 3, if there's a third infringement related to the same IP address, then your case might be referred to a tribunal, and this tribunal might find you guilty of negligence for not correctly securing your home connection, your home internet access. The sanction may be a fine, and it may come, as I was saying, with a possible suspension of 1 month of your internet access. The Hadopi is doing other things. It does studies, it has labs, but it also has a mission to promote the legal online distribution of cultural goods. So that's the mechanism. What has it produced in 2 years, from 2010 to 2012. As far as strike 1, the first email is concerned, there has been 1,200,000 emails that were sent. In 30% of the cases, only 1 copyrighted work was concerned. So if you had just 1 work related to your IP address, the circulation of 1 copyrighted work related to your IP address, you could get this email warning. Strike 2, so the second email plus the registered letter, the more formal warning that your connection has been used for illegal circulation of copyrighted content, 100,000 of such warnings. And strike 3, 360 internet users who never showed any sort of reaction to their second emails. They were invited to meet the Collège de Protection des Droits de la Hadopi, and only 14 cases of those 360 users, 14 cases to date, were referred to the tribunals. There have been, as of today, 3 decisions. In one case, 1 person was fined to 150 euros. There was 1 condemnation without the sanction, and 1 person was discharged. You have to compare this to the study, the impact study from 2009 from the Ministry of Justice in France, who foresaw like 50,000 judicial suspensions of internet access per year. There's been none so far. As concerns the promotion of legal online distribution, the IDOP has set up a label, which is pure in English for Promotion de l'utilisateur responsable, the promotion of responsible users. And it has a website which currently attracts about 9,000 visits per month. So does this actually work? And there's a few comments as to the assessment of this mechanism. And I've called this slide disproportion because if you refer it to Article 10 of the European Convention of Human Rights, you know that every infringement on free speech has to pass a test of proportionality, and these are a few reasons why I think the IDOP law does not pass this test. The administrative authority claims that it has achieved some success in terms of educating the internet users, because it says that most people who get the first or second warning, they stop using their own connection for downloading copyrighted content. At least they declare that they stop using their connection in that way, which is another way to say we don't know about other methods of getting content from the internet. It only concerns peer-to-peer networks, and it's not doing any work on the other ways like direct download or the streaming. It also seems to target mostly the small fish, the individual users, and not the heavy downloaders, which may be, by the way, just as every people who infringes copyright might be referred to criminal courts on another existing legal basis. So it seems that it's two ways to pursue the same problematic situation. And also, when it's claiming to educate the people, to educate the internet users, well, maybe in some cases it actually reaches this goal of actually helping the people realize that actually there is intellectual property and they should not use their home internet connections in that way according to the law. But I would agree, of course, that we live in times where there is a very high need for maybe higher IP awareness and mostly more internet literacy awareness and knowledge. But I think the system that has been created by the IDOP mostly promotes a culture of surveillance, and that's not what the internet is all about. I would say it's about, participation, sharing, etc. So as a last word for now, I would just say this to open for discussion. I believe there are other ways to generate income for the right holders.
Great. We look forward to hearing that. And so I did a small calculation based on your slide. So is it correct that the state, the French state, paid or spent approximately 10 million euros per year on this program, where there have been 60 people convicted?
No, there have been actually convicted people. There have been three cases before the tribunals. Okay. And that's 2 condemnations. And out of those 2 condemnations, one was without any sanction, and the other one was 150 euros fine, which is not much if you compare with the annual budget and 60 people working for the IDOP.
Well, that might be good to know in future discussions in this panel, hopefully on what can be left to the market or where should the state intervene, because this is only one European member state, but imagine the costs that are pushed into the public through systems like this, especially in times of austerity. I think those are important questions too, but I didn't know it was that big of a figure, so I learned that. Thank you. I would now like to ask Dimitri to take the floor. He also has some slides, so we're doing another little seat rearrangement. He'll speak in Russian, so you can already get ready and take your headsets.
Добрый день. Я прошу прощения за то, что я выступаю на русском, хотя не очень этого стыжусь. Просто мне кажется, чтобы несколько повысить эффективность моей речи и обеспечить ее сжатость, мне было бы удобнее разговаривать на родном языке. Я сразу бы хотел обратиться к тому, о чем говорили предшествующие коллеги. И в частности, говорить о некоторой лукавости статистики. Действительно, процесс измерения, скажем так, доходности, прибыльности бизнеса в области в области интеллектуальной собственности, он показывает, что, например, рост продаж книг действительно увеличивается. И в России, например, эта тенденция тоже есть, о чем говорил коллега. Но, с другой стороны, абсолютно такая же статистика показывает, что при этом, например, DVD продаются все меньше и меньше, и компании, которые, собственно говоря, реализуют DVD, уже постепенно отказываются от такой формы распространения, как DVD. Мы также можем вспомнить недавний пример компании Virgin, которая закрывает все свои магазины во Франции, так как не выдерживает конкуренции по распространению аудиовизуального контента в интернете. Так что статистику ее можно действительно смотреть по-разному. В качестве примера российской статистики можно указать на то, что наряду с Китаем Россия год за годом лидирует в рейтингах потребления контрафактной продукции в интернете. Крупнейшая социальная сеть России ВКонтакте регулярно упоминается американскими организациями по борьбе с пиратством как наиболее крупный поставщик контрафактного аудиовизуального контента в мире. Речь идет о потреблении сотен миллионов, скажем так, о просмотрах, сотен миллионов просмотров нелегального контента. Отчасти такая ситуация в России связана именно с отсутствием надлежащего правового регулирования. Правообладатели в России не имеют эффективных инструментов защиты нарушенных прав. Вопросы ответственности так называемых посредников, то есть интернет-сайтов, социальных сетей, поисковых машин, в российском законодательстве не решены. В частности, на мой взгляд, одним из самых существенных проблемных моментов является то, что в России нет такого инструмента, как существует, например, в Соединенных Штатах. Это Digital Millennium Copyright Act, то есть та же система, в общем-то, 3 ударов, но только на американский лад. В России она тоже не функционирует. В настоящее время такой закон в России принимается, я уверен, что к концу года он будет принят, и, в принципе, мы выйдем на тот уровень, который есть у большинства развитых стран мира, по крайней мере, с точки зрения законодательных норм. Насчет правоприменения будет понятно позже. Но мы в России, как и, в общем, во всем мире, сейчас находимся в состоянии дискуссии, а что же должно происходить дальше, как должно развиваться регулирование интеллектуальной собственности в интернете. Как показывает практика, европейские, американские и европейские страны и Соединенные Штаты не удовлетворены той ситуацией, которая существует в регулировании интеллектуальной собственности. Появление таких актов, как СОПа, проектов актов, как СОПа, ПИПа, АКТа, свидетельствует о том, что баланс интересов между участниками рынка на сегодняшний день не найден. В России, собственно говоря, тоже ведется речь о появлении каких-то документов, которые могли бы ограничивать деятельность пиратов в интернете. У нас есть очень либеральные позиции, такие как высказывает Российская пиратская партия. У нас есть гораздо более жесткие позиции депутатов нашего парламента, которые предлагают вводить фаервол по типу китайского, чтобы не пропускать ни экстремистскую информацию, ни вредную информацию, ни пиратскую, в том числе информацию. И у нас есть достаточно сбалансированные позиции. Вот я бы хотел представить такую сбалансированную позицию, которая была представлена в 2008 году российским президентом Дмитрием Медведевым. Я сразу говорю, что, конечно, эта позиция, которая была направлена лидером G20, не была разработана непосредственно Медведевым, но была разработана с привлечением российского гражданского общества, в том числе с привлечением Ивана Засульского, который упоминался на прошлой сессии. Это такой видный активист нашего интернет-движения. Итак, господин Медведев, я все-таки буду говорить, что это сделал господин Медведев, предложил изменить некоторые принципы, которые относятся к защите интеллектуальной собственности в интернете. Мотивация, собственно говоря, представлена на этом слайде. Она состоит в том, что не очень хорошо видно, да, в том, что техническая модель, которая легла в основу предыдущей версии регулирования интеллектуальной собственности, была построена на иных технологических принципах. И, собственно говоря, нынешняя ситуация требует концептуального изменения той системы регулирования отношений в интернете, которая существует на сегодняшний день. Я сразу оговорюсь, что президент Медведев предложил реализовать эти принципы путем изменения именно Бернской конвенции о защите, скажем так, контента, исходя из того, что, по его мнению, этот документ является основным и, собственно говоря, наиболее согласованным во всех странах мира, которые более или менее признают концепцию интеллектуальной собственности. Итак, первый базовый принцип, который должен лечь в основу этих изменений, это установление квазисвободного использования контента пользователями сети интернет. Юридически эта модель реализуется в презумпции свободы распространения контента. То есть правообладатель подразумевается, как согласившийся на то, что его контент будет использоваться свободно. Для того, чтобы изменить этот принцип, правообладатель должен направить именно уведомление тому пользователю, который использует контент не так, как хотел бы этот правообладатель. Иными словами, на правообладателя ложится достаточно существенная нагрузка по контенту, по контролю правомерности использования его контента. Также принцип свободы распространения контента должен гарантировать права неким специальным социально ориентированным субъектам, таким как электронные библиотеки, осуществлять перевод контента в цифровые копии и распространять его безвозмездно, бесплатно. Также не получая на это согласие правообладателей. Но при условии того, естественно, что такие библиотеки не создают возможность бесконтрольного распространения контента в интернете. Еще два средства, которые могут обеспечить свободное распространение контента в интернете, это стандартизация, то есть вынесение на общий уровень тех свободных лицензий, таких как предоставляют Creative Commons и GNU, для того, чтобы модель свободного распространения стала общемировой и общепризнанной. Еще одним способом обеспечения свободы распространения контента является, собственно говоря, размещение ссылок в интернете на правомерно обнародованный контент как свободная форма распространения информации, которая не требует согласия правообладателей. Наконец, собственно говоря, сама концепция контента должна измениться. Контент как категория цифрового содержания, цифрового носителя должен стать самостоятельной формой творческой работы, творческого произведения, защищаемого авторским правом. Этот принцип необходимо уточнить, исходя из того, что сегодня Бернская конвенция воспринимает работы, защищаемые авторским правом, именно как содержащиеся на материальном носителе. Соответственно, если материального носителя нет, то вопрос о защите авторского произведения тоже ставится под вопрос. Таким образом, по мнению Медведева, в общем, я тоже его поддерживаю, необходимо введение категории контента как отдельной формы выражения произведений, которое защищается авторским правом. Наконец, существенным фактором того объединительного процесса разработки международных стандартов защиты авторского права должно стать регулирование статуса посредников в сети интернет. Посредники, которые предоставляют интернет-услуги, а именно интернет-провайдеры, владельцы сайтов, доменных имен, а также системы поиска информации, должны отвечать за нарушение авторских прав, но только в тех случаях, когда это предусмотрено неким согласованными правилами. Именно о согласовании таких правил, собственно говоря, и говорится в предложениях президента. В принципе, эти правила похожи на ту концепцию, которая сформулирована в Digital Millennium Copyright Act, но, исходя из того, что это предлагается внести в Бернскую конвенцию, такие правила должны стать общими для всех. И, как мне представляется, именно четкость этих правил должна обеспечивать защиту авторских прав для тех правообладателей, которые заинтересованы в этом, при условии поддержания той свободы распространения информации, о которой я говорил раньше, которая достигается теми средствами, о которых я озвучил раньше. Ну и, наконец, это такой несколько уже специальный тезис, но он, в общем, касается, опять же, той концепции изменения политики защиты интеллектуальных прав, которая была озвучена. Она состоит в том, что критерии конвенции, Бернской конвенции о определении страны происхождения работы должны быть также изменены. В силу трансграничной системы интернета невозможно установить место публикации контента. С учетом того, что место публикации контента влияет и на защиту интересов правообладателей, и на собственно говоря, защиту контента на территории той или иной страны, этот принцип также должен быть определен. Как мне представляется, и, собственно говоря, господин Медведев также об этом говорит в своем послании G20, те предложения, которые здесь изложены, они не содержат каких-то окончательных рецептов, как и что должно быть изменено. Но однозначно та дискуссия, которая поднимается в результате, собственно говоря, публикования этих предложений, как мне представляется, может быть очень позитивной и должна влиять на те процессы, на те международные процессы защиты интеллектуальной собственности, которые сейчас идут в мире. Вот вкратце то, что я хотел сказать.
Thank you for that perspective from Russia. I have two short questions after your presentation, which had a lot of substance for further discussion. But one question is, what is the price of a DVD in euros or in dollars?
Legal DVD.
Yes, legal.
Something like €4, I think.
€4?
Yeah.
Legal?
Yes, legal. Yeah.
Yes? Okay, and the average income, I just looked it up, is $790 a year in Russia. So that's something to keep in mind when we're talking about the access to culture as well in the traditional forms. And then I had another question regarding the new deep packet inspection laws in Russia, which were adopted a couple of months ago. Were they also adopted with intellectual property rights enforcement in mind, or was that not part of the political debate around the deep packet inspection granting authority to the government to look into packages of email?
Well, actually, I have to say that unfortunately in Russia, intellectual property protection laws are not in the focus of our parliament, for example, as well as the president. Well, the president at the moment. Those acts you mentioned, they were enacted in order to provide protection of, first of all, children from the information that may harm their interests and their development.
Okay, thank you. I'm sure we'll talk more about the Russian situation and international context as well. And then we'll hear the last introduction from Robin. Thank you for your patience and get your questions ready.
Thank you, Marietta, and thank you in particular to the organizers, OSCE, for organizing this event and inviting me to participate. It really is a privilege for me to be here, and quite an honor to be back in Vienna. It was over a decade ago here in Vienna where I came up with the name IP Justice for my organization. So something about walking around these incredibly inspiring streets, was able to do that. So I would like to sort of take a step back and talk a little bit about the history of copyright and its relationship to freedom of expression historically and how it's evolved. We've just heard a lot from different people in different parts of the world how copyright is being used nowadays, largely as a tool of censorship. And I'd like to take a step back to how copyright actually began, which was as a tool of censorship. Copyright was first created as a response to this revolutionary new technology called the printing press. And you can imagine that the powers that be were a little bit nervous about this printing press because now ideas other than their own could spread easily. So they created copyrights sort of as a king's copyright, and it was a privilege, a right to be able to publish things. And that was the way that the kings were able to prevent seditious ideas and ideas that they didn't want to spread from spreading. They would refuse to issue this copyright. So it began as a censorship tool when it was first created. However, it sort of evolved, and in 1710 in the UK they passed the Statute of Anne, which really took a different turn to copyright. And that was when copyright was really reformulated and rethought, and there was a recognition that it could be used to promote knowledge and to spread learning and education. And so it was reformulated in the Statute of Anne, and that's what the U.S. copyright system and many copyright systems ultimately come from, was this Statute of Anne, which had copyright as a tool of education and learning. So you can see there's a little bit of distinction there. It was created at a time when, in order for knowledge to spread, words and ideas had to be affixed to something tangible, like a piece of paper, and handed out that way. That was how ideas had to spread in that world. But we live in a different world now, where with the simple press of a button, you could send to billions of people your ideas on Twitter or anywhere. So it is important to realize that we live in a different world now than when the copyright was first created and formulated. I think it's also important to recognize the relationship between copyright and freedom of expression, that they're really two sides of the same coin. When you've got copyright now, it's about the author's right, or the corporation that purchased from the author, their right to control what happens to a particular idea. But at the same time, that is also a restriction on the other side of that coin to what the public can do, what the public can say and share and distribute. So it's always going to be two sides of the same coin. You can't talk about copyright without talking about freedom of expression, because it's a balance between which side are you going to give more rights to, more power to? Is it the public to use words and ideas freely, or is it going to be the authors, creators, and the corporations that employ them? And so it must be this balance that is struck between these two concepts, and you can't give greater copyright protections and greater copyright enforcements without impacting the other side of that coin, which is freedom of expression and what people are able to do with the ideas and information. So now we've heard again how copyright is now being used as a tool of censorship. People and copyright statutes, governmental statutes, and try to prevent those from being disseminated. We saw historical speeches, historical photographs, things of immense public significance to all of society are copyrighted and then controlled. The uses are controlled by the copyright owners, again, in order to ensure ideas only flow in certain ways. So copyright is unfortunately returning back to its beginnings as being used as a tool of censorship in its current formulation, and as a result of the internet, because lawmakers were very nervous about the internet and how information and ideas can spread, that was the response, was to go in the other direction and give too much protection and too much enforcement. And so we're returning back to where it began as a tool of censorship. Thank you.
Thank you very much. Do you think that the current legal model is sustainable? So what if nothing is done to reform from the government side? What do you think that will lead to?
Well, I don't think the current model is sustainable. I think we have to explore, look at new business models. We have to look at the properties of the internet. What does the internet provide us with? It provides us with an ease of copying, an ease of distribution. These are the properties of the internet. These are the properties that should be harnessed. Unfortunately, it's sort of the opposite. The reaction has been, because of these ideas, we need to clamp down. We need to restrict the flow of that information. So I think we do need to have a reformulation and a look at new business models, and ones that don't try to fight against the properties of the internet, but rather embrace those and can harness those in order to provide more remuneration to artists and authors, which is, I think, what we all want. We all want to live in a world where artists are rewarded and encouraged, and we want them to get paid. The problem is this current model doesn't work. It's broken. It was created for a time when there was ideas and information existed in scarcity, and now we live in a world where these ideas and information can be distributed with abundance, and so we need to reformulate our thinking of how we approach, how do we encourage the creation of artistic and intellectual works. Thanks.
Thank you, and that's going to be the billion-dollar question. How is that model going to look? So let me just look around the room. Reactions to the panel, questions. If people with questions could move to this lady over here with the microphone. Or, yeah, as you wish. But we do need a microphone, otherwise the streamers at home can't hear you. And I'll come back to some remote questions after this first question.
Away from that repressive measure, and what we see today is that every time industry is pushing for new ways of attacking what they define as being the problem, and each time we end up with fundamental freedoms being attacked. So maybe the definition of the problem here is what is wrong. And so what we suggest is that instead of vainly chasing the very same ghost that sharing is bad and sharing hurts society, maybe we should look at the usage first, and which usage are part of our cultural processes today. For instance, what we advocate for in our elements for reforming copyright and related policies is that we should make maybe a distinction between the sharing of works for profit, where you have commercial actors that you can go for, and maybe we should concentrate the means of enforcement on this for-profit infringement of copyright, but then at the same time, the not-for-profit sharing of works between individuals, we advocate for it to be legalized. And so this would be a way to end this war on sharing, to concentrate efforts on something else, maybe to think of new mutualized ways of funding creation like we've done in the past with blank media levies, music on the radio, and things like that. But start with the usage. The sharing of files between individuals doesn't hurt culture. It's the way culture always existed.
All right, thank you for that suggestion. And just from the receiving end of proposals and opposition to proposed legislation, I think it is essential that those who are against measures like ACTA or SOPA or PIPA or other kinds of copyright enforcement are trying to be a part of the solution. So I think that that's really much welcomed and going to be essential in moving this debate away from pro or against to a new model. And the question that is often used by almost every lobbyist, no matter what they're advocating for, is that artists and creativity need to be encouraged and rewarded. And that's fascinating because some Some do represent artists and some don't, but perhaps we can also think about how these business models would look. So where would money be made, and how would it be distributed? I think we have a question from the remote participation first, and maybe I can see a show of hands of people in the audience, or otherwise I'll turn to the panel again for some comments on each other's introductions. You have one question? All right, let's go to remote participation.
Yeah,
then to Sandra.
there is a remote question on Twitter regarding the Russian draft law or proposed legislation about the status of this, whether it's a mere proposal or whether it has been introduced in the legislative process, or what's the status of this law, was asked here.
It is in Parliament. I think that the first reading took place a few months ago, and so I think that by the end of maybe this autumn, we will have this law enacted and passed through the Parliament.
Hello, my name is Sonia Kelly, and I work at Freedom House. My question is related to the assessment by the panel that the current system is broken, and a lot of legislative proposals that we've seen so far had really tried to tilt the balance towards the rights of copyright holders as opposed to freedom of expression, and that was obviously a huge problem. But my question is specifically for the panelists, what do you then personally think should be the rights of copyright holders? And I can even give you an example. One of my best friends is a photographer, and she posts her photos online as part of her profile, and she sells those photos to agencies like Reuters and Associated Press. But she also consistently faces an issue where people will just download her photos and, post on different websites and so forth. So specifically, what rights should she have to essentially protect what is her key income? Thank you.
Who in the panel is interested? Yeah, Joe.
I had a few different comments. Before I come to the last comment, the internet started growing in Western Europe around 1995. That's when I started working in the internet sector. In 1999, there was a case against a German ISP because the ISP had hosted some MIDI files, if any old people here remember what MIDI files were. And the music industry plaintiff said that the ISP must have known that the files were not authorized because there was no other, you couldn't buy MIDI files. So the irony of the fact that you couldn't buy MIDI files seemed to have been lost on them. In 2003, according to the International Federation of the Phonographic Industry, there were fewer than 50 legal music services, but there were some. Would they have grown without there being infringements? I would suggest possibly not. The only country that I'm aware of in Europe that has a thriving open licensing regime for online content is Russia, where the content industry feels the need, because of the legal framework, to protect itself with innovation and not protect itself with law. Although whether this is going to still be the case after the law is introduced remains to be seen. Regarding the question that was asked, people need to realize what the internet is. If you put content anywhere on your doorstep, on a telegraph pole that is interesting, it is possible that people are going to take it. We shouldn't hold the phone company liable for the telegraph pole. It seems perfectly reasonable for your friend to post her photos with a little notice in the corner saying not authorized for publication apart from here, and people can contact her for an authorized copy.
She does that, and people still copy it. Every photo has a little line saying exactly what you're saying.
Saying it's not authorized.
Yes.
I would like to see that, but okay.
And a lot of people do that.
Yes, but on the other hand, just to, sorry, I just wanted to react to this, because if you put on the internet photos that are of a sufficient quality to be published on the web, they are not of a sufficient quality to be used for a professional publication on paper. So that's one way. What you're going to put on the internet is not going to be printed because it's not of sufficient quality. Second comment I wanted to make is if you put things on your doorstep or on your website to be shared, of course you may be losing something because some people will use your photos without your authorization, but what do you gain? You gain the reputation, you gain the fact that you're known, you gain the fact that your work is known and spread over the internet. So that's part of the balance when you decide to put something on the web. There may be a risk, but there may be also a risk of winning, of gaining in the equation.
Barbara, did you also want to respond?
Yeah, I wanted to make similar comments, but also maybe your friend would be interested to know that, many companies take also restriction to the photography, and they are claiming that taking pictures of the buildings on the grounds of reproducing pictures are infringing their copyright. So maybe your friend would not, like that either. So if she takes a picture of the building, she already maybe infringed the design of the the building, and she reproduced it. So I mean, it's more complicated than that. But I would definitely echo to what other people said, that how you put the pictures on the internet and why you're doing it to promote your business, and you can also benefit from it. But also I wanted to go back to what Jeremy said and what Jeremy proposed about looking at the remedies and looking at what is the usage sort of side of the coin. And Article 19 argues for creation something which is called the right of personal enjoyment of cultural goods, which would include the right of everybody to read, listen, view, browse cultural goods without copyright restrictions, including online. And that also comes with our sort of campaign to decriminalize the non-commercial copyright infringement in Europe and around the world. And it's actually quite worrying that in many countries, including in the OSCE region, even non-commercial infringement is criminal. And that's absolutely disproportionate sanction and violation of the right of freedom of expression, which has to stop, and we have to do that as well.
Yeah, I just wanted to respond to the idea that there can be, or that there should be, this leak-proof pipe that nothing can get out of, and no one's ever going to be able to make an illegal copy of, is a fallacy. We have to accept that there will be some copying on the internet. That's what the internet is. It's a giant copying machine, and there should be this kind of breathing space in copyright that allows for a certain amount of non-harmful, non-commercial, personal use of things. So, if our friends are waiting for the day when they can put things on the internet and nobody other than them is ever going to be able to do with it as they wish, they're living in the wrong world. I think while the internet provides for a lot of copying, it also provides for a lot of ways of tracking that down, tracking down the person. I mean, if it's there on the internet and it's got her name on it, it's easy there's the infringement, go get them. So on the one hand, it has provided the opportunity for the infringement, but it's also easy to track and somewhat easier to stop, because the internet is making a large evidence of what is happening.
Yeah. Just a second for the mic, please.
Hi. Darian Pavli from the Justice Initiative. I have a question for the panel generally. In terms of what models are emerging, I feel that whenever we talk about copyright, we're somewhat in the defensive, because we're arguing for a fairly radical, fundamental change in the way the system works right now. So there's a certain evangelical side to it, which is not necessarily a bad thing, because sometimes it takes a lot of time. But are there specific models that are emerging that we like? Is there one country where we've managed to sway public opinion? I mean, I know we had some pretty major victories, we defeated some bad things, but but it hasn't radically changed the way things work, the legal framework, if we want, at the national level and international level. Is there one country where we managed to sway the public opinion, where there is specific proposals, reform proposals that we like? Thanks.
Doesn't look like like there are many countries. Well, maybe maybe I can ask Joe to say a little bit about trends, because, you know, on the one hand, we should look for best practices, and I do think that there are, you know, that there are lessons to be learned from also the French government now revoking Hadopi, because they're saying that it was actually too expensive and not very effective. I know that in the Netherlands, where I'm from, there are increased discussions about flexibility. We have already a stated objection to criminalizing the individual downloader. So basically, illegal downloading is no longer a term that's used in the Netherlands, because the labor union for performing artists, as well as the consumer rights union, together came out and said, you know, no matter how to assess the impact of piracy, we are never going to want to be in a position as musicians that we want to alienate and criminalize our audiences. People make music or things, other creations, to be heard, to be enjoyed. And that was, I think, a hopeful statement, and also one that's quite unique, I suppose. The other trend, though, regardless of the positive examples, and maybe Joe has some, is one where there's an increased push for self-regulation. And I think it is appropriate that we spend some time on this panel as well, where there is the suggestion that companies can just work it out between themselves, or that governments say, well, it's very difficult for us to see who is a commercial downloader and who isn't, so what would be very effective and also cheap for us is when internet service providers simply scan internet traffic, and they can figure out who is performing anything potentially illegal that we should watch out for. And that is a contested issue, because it would effectively mean the privatization of law enforcement online. And so I hope Joe is willing to to step in and say a few words, but anyone else who wants to, please feel free. And then maybe I can also see some more hands from the audience if there are some questions. All right, Joe, go ahead.
On self-regulation, you can't self-regulate somebody else. It's a problem. It's a problem of our dictionary. And it's a problem of basic logic from the content industry, which has driven me bananas for years. The content industry believes that internet intermediaries are the source of all evil. They're making all of this money, they don't say how, from infringements. And if only they would step in and stop it, then we'd all be happy people. So the internet providers are evil. Simultaneously, the internet providers are wonderful, according to the content industry, because the internet providers are so good and so pure that we can rely on them to regulate our freedom of expression. And whatever they want to do is going to perfectly match the needs of society. So these all evil, pure, wonderful companies are going to solve the problem. And the punchline of the joke is about to come, because the net neutrality discussion is reaching a peak. Net neutrality is basically whether or not internet companies should decide what people have access to and what they don't have access to, depending on their own competitive interests. So one of these mornings, the content industry is going to wake up, and it's going to get what it always asked for. It's going to get the internet companies as the gateway between the citizen and the internet. And that day that they get what they want, they'll suddenly realize that gates can keep people in, but they can also keep people out. And they're going to have to do deals with the internet providers to work out who gets through the gate, and they're going to have replaced one problem with another problem. To the trends, we nearly sort of had a nice trend. The European Commission produced a communication in December of last year. And the speeches were very good. And one of the paragraphs says, the following elements need to be addressed. Territoriality in the internal market. Harmonization. Limitations and exceptions to copyright in the digital age. Fragmentation of the copyright market. And they even questioned the legitimacy of enforcement as it currently stands. Fantastic. The Commission identified the problem, and by God, it was going to do something. Sometime. So in last week or the week before, last week, the Commission launched its Licensing for Europe initiative, or Licenses for Europe initiative, where they invited lots of lobbyists in and said, we need to solve the problem. Oh, you need to solve the problem. Can you sit around in working groups for a few months and solve all of the problems, please? Oh, and you're not allowed to discuss who said what outside the meetings. And, oh, there's not going to be any live web streaming. And you're not allowed to discuss the law. And this is what we got instead of the reform. And the Commission just has another 13 months, and that'll be the end of the current legislature, and it'll move on. So we nearly had a trend. We nearly had something nice. We've got nice words.
So maybe governments are sometimes not, advancing digital freedoms or sort of modernization of access to knowledge and culture. But let's say we would leave the development, sort of the fights or the struggles between internet companies, internet users, and the content industry just up to the market and the courts. Where would that take, for example, the production of music and movies in 10 years? I mean, if nobody does anything anymore in terms of trying to reform the law. Maybe I'll also turn to Robin because you wanted to come in. I'm sorry, I didn't want to skip you, but I think the real question is, because, I've been hearing a lot also from the audience, and I'm observing the trends, that there's a lot of resistance against proposals that are coming out of government, and I can understand why, so I'm not trying to defend these proposals. On the other hand, there's an assessed need for reform by some of you in the room. And so, can we trust government to come up with wise decisions, or should we just accept that the market will fight this out, and that the level of the balance between the influence and the power of the content industry vis-a-vis internet companies will gradually shift towards a more accessible model where middlemen, as they're called, so in-between players who used to ship CDs, DVDs, melt plastic, and do all kinds of things that are no longer necessary, may no longer need to fight for their share of the pie. I don't know if you can tag on to this, or do you want to?
I had a comment on the self-regulation.
Oh, yeah, go ahead. Back to self-regulation, and then we'll talk about, can this just be left alone, or should we really fight for reform on a legal level? Go ahead.
Yeah, there is one forum where self-regulation supposedly happens in the space, and that's ICANN. I don't know if folks are familiar with ICANN, the Internet Corporation for Assigned Names and Numbers, which manages the domain name system. And they're a private California corporation based in California, but it's also at the same time an international organization because there are governments that participate. There are all these different stakeholders that come and negotiate what the policies are going to be about the use of domain names. The problem is that it is largely dominated by the intellectual property rights attorneys, by a long ways. I participate at ICANN, and I'm the chair of the non-commercial users stakeholder group, and so there's a very small number of us, and at the other side of the table is the intellectual property rights constituency and the business constituency, which are really one and the same, but they get two because, well, when ICANN was created, they seemed more important, and the internet service provider constituencies and the registries and the registrar constituencies. All of these are businesses, all these are commercial stakeholders, and then so on the other side of that table is us, the non-commercial stakeholders, and we try to advocate for freedom of expression rights in these policies, privacy rights in these policies, and I can tell you we are so outnumbered and outgunned by this self-regulation model that it, to a large extent, isn't working. And if I could also take this opportunity to make a plea to those of you here today or listening over the internet who care about freedom of expression on the internet, please come get involved at ICANN with the non-commercial users. We really need people who care about freedom of expression there. There are proposals on the table now that the Intellectual Property Rights constituency put forward, very similar to the PIPA, domain name blocking proposals. Nobody really knows about that. It doesn't have the same kind of exciting catch that some of these legislative acts have, largely because it is this private California corporation and nobody thinks they have to pay attention to it. But at the end of the day, the policies that come out of ICANN affect everyone who registers and uses a domain name. So it's extremely important that we get people who are concerned about freedom of expression, concerned about human rights, in these models of self-regulation, because without it, we're completely outgunned, and the Intellectual Property Rights constituency is entirely runs the show, and the governments that do participate at ICANN, unfortunately, the GAC, the Government Advisory Committee, is just a mouthpiece for the Intellectual Property Rights constituency. When the governments come out with a proposal, you can actually look at the header files and see that it was written by the Intellectual Property Rights constituency. So in that model, there are big problems with self-regulation, and we need more people who care about freedom of expression to participate at ICANN. Thanks.
Thank you. That's another important dimension. There was a question in the room, and perhaps more now. Yes?
Thank you. Does it work? My name is Helga Mühling. I'm from the Austrian Ministry of Innovation, but I'm expressing my own opinion here. First of all, the European Union undertakes huge efforts to stimulate innovation. But I doubt that a climate of over-regulation really does encourage innovation, and that it would help consumers and creators alike. This is one thing. More specifically, referring to the e-books you mentioned, Mr. McNamee, our traditional concept in our law system is that you are owner, you can do whatever you want. You purchase an item, you can destroy it, you can share it, whatever you want. If you are buying an e-book, you are not consenting to lending it. You are consenting to buy it. That makes a difference. And I doubt that our concept of ownership, our concept of purchasing, is really adapted to that what's going on presently. I think we should make sure that it's for the benefit for the consumers and for the whole of the population. Thank you.
Thank you. That's a key question, I think. Do you actually buy a lifelong lease of access to music online or to books online, or do you actually own it? Speaking of ownership, which is often used as a key argument for strong enforcement. And I believe, but maybe someone in the audience can help me if I'm mistaken, that in the United States there's currently a lawsuit about this around inheritance. So what do you do with your music collection? I think it's even Bruce Willis who's putting forth this case. What if you die and you cannot pass on your music collection as you could with those, LPs from Michael Jackson and others? There's another question here in the front, and then I wanted to do a little poll in the audience and give panelists the final word, so to both answer the questions and any other thoughts that have not been raised. Yeah.
Thank you. My name is Marcin Olender. I represent the Polish Ministry of Administration and Digitization. Just perhaps starting from what my colleague behind me just said, because I would like to ask your thoughts about the recent Oracle Newsoft decision of the tribunal, and what effect would that have on e-books and perhaps music? Does this should this be seen as perhaps paving the way to full transferability of non-material copyright works? That's one question. The other one I would direct to Mr. Golovanov, because we as a government agency, we are trying to foster a debate about changes that need to be made to the copyright system, and we are facing massive a sort of backlash from it's not just creative industry as such, it's individual artists, and it's a very, very strong force pushing back. So the question is, how would we deal with such a force that is so attached to the current system of copyright that it's really difficult to. We are perhaps an unusual government that's trying to push in a different direction, but we are facing stiff opposition. So the question is, what arguments can we use to perhaps succeed in some sort of reform? And I did have a third question, but it slipped my mind. So I will just, I think, end there. Thank you very much.
Thank you for those two final questions. I just wanted to ask, before we give the panel the last opportunity, is who of you thinks that the current copyright management and enforcement system works fine? Nothing needs to happen. One, okay. How many of you think there should be a legal reform introduced through government? And how many of you think that the market and the courts and innovation and new business models will sort this out without any intervention?
I want a mix.
Yeah, I mean, but just to get a sense of where your thinking is. Okay, great. So maybe I'll start on the left. Is that okay, with some final thoughts on leasing models, News Corp and Oracle, and the backlash from artists vis-a-vis the proposals in Poland to reform?
That's a lot in the final few words. So I just want to. We've spoken about important stakeholders like the content producers, the ISPs, the telecoms, the IP right holders. Maybe we should also think about the individual users. And it seems that people accept to participate in things like crowdfunding. It seems to be an important way from new content producers to find money to produce their things. And so an important, is just an opening final thought, but a way to think about this is also thinking of the role of the individuals, to let them choose what they want to consume, because they can be responsible on their own, and let them have their say in the production of content. I think that's an important when this is just a way of reacting to the claim of Adobe that it has been educating the internet user. Well, there's another sort of media literacy or internet literacy work to be done, and I think involving the users in the production of content would be an important dimension of policy.
Pierre just mentioned Kickstarter, and I think that's a really good example of a new kind of model that's come out that is really doing a great job of funding artists' productions and works. Just last year alone, there was more than $320 million in the U.S. put into Kickstarter campaigns to fund artistic works, encourage creators to create that don't depend on the old model. So I think that is one good example. In my own private practice, I've had clients who have created videos and put them up on YouTube. It got really popular on YouTube, and then they were offered their own show on National Geographic, and it was because they used the internet to reach people and to get their ideas out there. So I think that turning back to Marietta's question of how are we going to get there, I think it is a mix of experimenting with these new business models and trying new things, and we're going to make some mistakes, but just being willing to try new things is so important. And at the same time, we have to recognize that this overreaction of clamping down, ratcheting up intellectual property rights and clamping down on enforcement is having the effect of stifling innovation, stifling creativity, stifling freedom of expression. So I think we have to work both on both avenues. We have to reform the law because, people are being put in prison for downloading a song. I mean, that's not right. We have to explore the business models, find new ways to get money into artists and creators' hands, because we want that, we really do. But we don't want to have to depend upon a system that goes too far and infringes upon the rights of everyone else. Thanks.
Well, if you allow me, I would like to comment on several questions, several issues. First, it's a question: what can we do? How to deal with these lobbyists, like by major right holder companies, artists, and so on? It's very easy to answer this question. I don't know. Frankly speaking, this is one of the hardest questions concerning any regulation of the world, because these lobbyist structures, they are very strong, I would say, and they influence the lawmaking policy in the way that provides shaping into internet industry, and not in a good way. But on the other side, there are also, for example, users who are very disappointed with any actions like, for example, presenting Adobe law and any other law. So it's another lobby group which is very strong and very influential. I think that you have to, drift between all these groups to find some consensus between different forces. Second, I want to react to the idea that Russia uses innovation activities instead of using legal framework. Well, in order to protect economic interests of right holders and so on. I am a lawyer, practicing lawyer in Russian professional aggregator of video on demand content, which is legal. So we are very interested in providing legal content and fighting against internet piracy. So what is the initiatives for innovative mechanisms for fighting internet piracy? We actually had a few proposals from Russian companies. And here are examples of such innovation activities. For example, they say, we can provide you DDoS attacks on the biggest Russian online portals, online sites providing illegal content. Another way to use innovative technologies is to make hacker attacks to the sites to stop their functioning. Another example is to fill torrent sites with broken files in order to see their functioning. It's a very cheap and very effective ways to stop functioning of illegal websites. But frankly speaking, I don't think that this is a good way to provide interests of right holders, for example, of our interests. So for me, it is more proper way to create, to formulate new rules for all the participants of this market, but not to use the absence of rules, I would say. So, and I have two more comments. One concerning self-regulation. I maybe agree with the point that you cannot force somebody to self-regulate. But we have, for example, example of the United Kingdom, where the government say, okay, we will enact some rules which enter into force in, for example, in a 1 year or maybe 2 years. If until that time the self-regulation structures will not enact their own rules, will not develop their own rules, these governmental rules will enter into force. If otherwise, then self-regulation will do. So they do not force to self-regulate, but they provide some alternatives for self-regulation companies. I think that's a good way to solve this problem. And finally, you asked if there are any perfect country, which I provide the example of how to do with fighting illegal use of content. I think there are two countries. First is China, and second is North Korea, I think, because these two countries, they have, is isolated, perfect systems which they can regulate any internet relations concerning, for example, intellectual property law. But of course, it's a joke. But what I'm saying is that we are now, all our countries are in competing sphere. So we have to work together in order to formulate some rules which will be applied to any participant of this market, but not to any just one perfect country. This is my point. Thank you.
Thank you, and I'm sorry because we're already running into the break, and it may take a while to get coffee, so I hope you guys are all okay to stay for a couple of more minutes, but please know that we're already running over time. Yeah, Barbara.
Yeah, just very briefly. But I think that what we really have to go back, and I don't really like to have this conversation and debates really only focusing on the business models and income generated revenues. I think that what we really have to go back, and that's what I said at the beginning, is to frame this discussion in the human rights terms. And when we go to the existing human rights standards, we will see that as for the right to freedom of expression, it can be limited only in very narrow circumstances. And there is a three-part test which was elaborated by the Human Rights Committee, by the European Court jurisprudence, and it's very strict. And the margins of appreciation the countries have in this sense is very narrow. However, when we look at the human rights protection to the property and copyright, the states have actually much broad opportunities how to limit these rights. And property is actually one of the least protective rights in the human rights framework. And when you look at this debate, it looks like it's the other way around. So we really have to go back to the basis and the human rights argument on this topic and see it as a key freedom of expression issue. And also what we really need, and we haven't touched on this, is we have to unlock the public domain. And in this sense, we have to discuss and limit the expansion of the copyright terms and the duration of the copyright, which even recently in Europe was extended for sound works from 50 to 70 years, and it's absolutely unwarranted and questionable. And in the UK, the review of copyright reform suggested that there is no objective evidence for that, and there has been even discussion that it should go back to original 14 years. Or law. So we really have to look back then and then also look whether we really need the copyright extended beyond the life of the author. If we look at the other human rights such as reputation that ends with the life of the person, you can't sue for damage to your reputation after you are dead based on your relatives. So yeah, talk about things like stopping the copyright at the death of the author and not extending it beyond, and unlock the public domain in general.
Firstly, on term extension, which I wasn't going to talk about, the European Commission paid for, I think it was 3 studies to work out whether there should be term extension or not. They all said that there shouldn't be. So the Commission introduced term extension. Why do people think copyright isn't credible? I don't know.
Or the Commission. I don't know either.
The point that was made by Dimitri cuts to a very, very crucial question. Self-regulation faced with the threat, self-regulation, privatized enforcement faced with the threat of legislation. This is very important because you have to look at it from the company's perspective. The problem they are trying to solve in that circumstance is not the problem. The problem they're trying to solve is, how the hell do we get the government off our back? And they will do that in some kind of scattergun way that they hope will make the government happy. That is not an effective policy-making methodology. Commissioner Kroes said recently that she's not too keen on heavy-handed legislative measures. They aren't always needed. And I think that's the point that you were making several times. The problem is, if you've got heavy-handed legislative measures, then you have to get rid of them. And we've got barriers caused by territoriality, we've got barriers caused by licensing, we've got barriers caused by exceptions and limitations that aren't sufficiently flexible. We've got barriers caused by legal protections for digital rights management. We've got a lack of innovation, for example, for micropayments. There's a film that I'd really like to buy for friends, which is French. And the only place that it's available with English subtitles is Australia. Really, in 2013, why can I not download that film and pay somebody for it? How is it possible that there has been so little innovation? It's bewildering, and it's not going to be solved by protecting the industries that have failed to innovate.
Thank you. On that note, may I invite you all to be a part of the solutions that we desperately need by sharing best practices, by thinking of what governments need to do in the public interest. I think that was a very important addition to our discussion that may have lacked in the initial assessments and also in my points, but I think is essential. Perhaps that way we can sort of crowdsource a patchwork of perfect solutions for at least Europe, which would be very helpful. I hope we can all count on you for your commitment to the solutions and for support of copyright reform, which seems to be what the majority of this room believes in. But as in every democracy, you need a majority, and well, we'll need to make that happen. So thank you for your participation and your patience on running over time, and thanks especially to the panel for their thoughtful, specific and very eloquent remarks. So with that, I'll end.